Assalamu alaikum and welcome to your summer one semester. I'm very sad that I can't actually be here with you. I know a lot of you will be sobbing in the classroom, but I asked Alisha to bring some tissues along. And I'm happy to say that at least we'll be able to continue with the semester and get our introduction right underway without any impediment. Right now, as you hear this, I'll be at a conference in Ireland, but I don't think that's a reason why any of you guys should be suffering in terms of learning the importance of comparative law. So we'll go straight into it and we'll go forward with the introductory class. So let's go around the room and have introductions. But actually, before we do that, let me just go through the class and we can do the introductions later if you don't mind me suggesting so. So this is Law LGS 270, Comparative Law, and it's one of the required courses for all undergraduate students here who are taking the law degree at AUEF. And it's also very popular amongst students of political science and students of business and other disciplines, just because it's very important that students get a good understanding of the various laws that come to interact with one another here in Afghanistan and outside of Afghanistan around the world as well. So it's a course that a lot of students find a lot of interest in. It is a lot of reading, so you're going to really acquire this aptitude for reading high volumes of difficult readings, and that's a very important skill if you're going to go through a law course and also acquire some legal expertise, whether you're in the law discipline or not. So it's something that a lot of students will benefit from generally. And it's very interesting because you get to see different understandings of law altogether. So it's something a bit different than most of your courses if you've studied law beforehand. I know all of the students here will have studied Introduction to the Laws of Afghanistan, and some of you will have studied contract law, constitutional law, property law. Comparative law is a bit different because in comparative law, it's not that we're studying the content of any specific area of law. So when you study contract law, you kind of have an idea that you're studying a particular set of rules that govern contracts. Same as constitutional law, you're kind of studying a constitution of a country and has certain articles. But when we study comparative law, we're actually looking at the structures, the legal structures that kind of constitute a legal system and a legal tradition. We're going to get into those definitions. But we're not speaking about specific laws themselves. Rather, we're looking at the structure of law. And that's why some students find it a bit frustrating at the start, kind of understanding, the structure, focusing on the structure of law versus actual content of property or constitutional law. But as the course progresses, most students end up finding that the course is quite beneficial to themselves. And by the end of the course, at least up until now, the vast majority of students have said that it is something very beneficial for their academic learning. And just another side point, and that is comparative law actually isn't a required course in most law schools. I mean, there's only 3 that I'm aware of AUF being one of them, in the world that at least until now I'm aware of where comparative law is required. And to some degree, that's also because of circumstances. I mean, we find ourselves here in Afghanistan where we have common law, customary law, Islamic law, to some degree, the common law, and they're all interacting with one another in this complicated, nuanced manner. And so one of the reasons that we find it so useful studying comparative law in a place like Afghanistan is that you have that interesting mixing of laws with one another and interaction. And so it provides an impetus for actually studying this area of the law itself. So just a little, I'll skip the information about myself because it's not very interesting, and we can talk about that when I get back in a few days. Now, generally, what I'll do in this presentation is I'll tell you a little about, introduce you to the course that we'll be delving into for the coming 4 weeks or 5 weeks over the summer. Then also I'll talk a little bit about the assessment that we'll be using throughout the course. So, of course, respect is something that's extraordinarily important in a class like comparative law. You're going to find that it's an extraordinarily interactive class. I mean, I try not to talk more than 50% of the time. Any more than that, I think it's kind of lost information on your part, because the more a prof talks, the less that a student retains. So I'll be talking, maximum 50% of the time, The other part of the time, you'll be asking questions, debating ideas, discussing amongst yourselves what will be going, what your ideas are concerning the particular topic at hand. It ends up being a very lively discussion, I think especially when we get into the topic of Islamic law, but it ends up being a very lively discussion, and as long as the discussion remains respectful and is going generally in the direction that we want it to be going, I'm quite okay with entertaining as many comments as possible. And it's worked for the previous semesters, and I'm looking forward to it working again. But just remain respectful. If you have an opinion you want to make, raise your hand, and then we go around the class, and we almost, without exception, try to make sure that everyone who has an opinion or two opinions has their time and is given the spotlight so that they can present their idea and make their argument as well. So the issue is, what is comparative law? This is a really big question, which I'll even ask you again at the very end of the course. Because there's this famous quote by Yogi Berra, which is that you have to be careful if you don't know where you're going, because you might not ever get there. If you don't know where you're heading, you're going to be just going in a circle, but you won't end up ever getting there. So there's a big issue as to what comparative law is, because as I mentioned to you before, we're not studying like a law that's been passed called comparative law, the way you'd study a law that's been passed called property law or contract law. So in that sense, it's a bit different. And as quickly as the second course, we're going to get into this issue of whether comparative law, second class, we're going to get into the issue of whether comparative law is a method or is it a domain of its own. And so that's going to be an interesting question. So this is an exercise that I sent to you just before this class, and that is comparing the law on a particular clause in banking law in Canada versus Afghanistan. And through this exercise, we'll kind of look at why comparative law is so interesting. And as you see it from, you might not be able to see it from this presentation here, but you'll be able to see it from the email I sent you. In Canada, the law says the central bank, which we call the Bank of Canada, or where I live in Canada, the central bank may accept deposits for the government of Canada and pay interest on those deposits. So essentially what it's saying is that sometimes the government will have extra money, it'll deposit that money into the Bank of Canada, and the Bank of Canada will pay interest on that amount. In Afghanistan, we have the Afghanistan Bank, our central bank here, and it says the central bank may accept deposits from the state, and the central bank may agree to pay interest on such deposits. So the question that I asked you before class through email is, in what ways can these two laws be different? And let me be frank, on their face, they're not too different. I mean, this says that interest will be paid, whereas this says it may agree to be paid. So, I mean, that's one of the evident differences between these two laws here. But you don't really get into the deep understanding of the differences in these laws unless you understand the way that the legal systems and traditions in which they're housed, the legal framework in which these laws are housed, actually operate. You see, in Canada, what we have is a common law legal system. And in the common law, it's generally a case-based law, and you would have no problem with this particular clause. But in Afghanistan, as we know, we have civilian Islamic law. So it's a civilized structure, but as we know from Article 3 of the Constitution, no law will be inconsistent with the faith of Islam, or the religion of Islam. What you might recognize here is that interest is problematic in the Islamic tradition. So there's something fundamentally, potentially, we'll say, there's something potentially problematic with this law here in Afghanistan because of the way the legal framework in which our laws are housed operate. All laws have to be consistent with Islamic law. That's not the case in Canada. So in Canada, since there's no background or foundation in that sense, where laws have to be based according to any religious tradition, there's no issue with this clause in Canada. There is potentially an issue with this law being existed in Afghanistan. So I'm not going to go as far as to say, the Afghanistan bank law is un-Islamic. It's something just to be aware of. I mean, it does say may agree, which means that it's not something that's required. But just in the way that we understand these laws, what you should be understanding is that we don't want to just look at a law and read it and compare it and see how is it different. Because then you just would say that, okay, this is imperative where this is suggestive. This is saying, maybe a law should be, this is saying that interest has to be paid. Whereas in the other case, it's saying that interest may be paid. That's a very low-level analysis, and unfortunately, that's the majority of comparative law in the world today. It's just, reading a law, reading another law, and just seeing what the differences are. In fact, this is one of the shortcomings of the law and development field. Often you have this copy-pasting of laws from Georgia or Greece or some other country to a country like Afghanistan or India, just this copy-pasting of laws from one to another without understanding the legal framework in which each country houses their laws. So that's what we want to get into in this class, understanding that deeper, systemic, structural basis of the law, because that'll give us a deep understanding as to whether this type of law is appropriate in Afghanistan. Why does Canada have this law, and why might it not be appropriate for countries that have a very strong Islamic law influence? And this is the type of analysis we hope to get to in this class. I often bring up this example throughout the course so that we understand, comparative law isn't just about copy-pasting and comparing written laws that are enacted. It's about understanding the structures behind the law. This is another case that example that I sent you last night, and that is, let's just say that you've been hired by the UN as a legal analyst, and as a legal analyst, you're asked to create a simple database for court cases. You want to know in that database, how do you reference cases? So you might look to a couple of jurisdictions. In some jurisdictions, like the United States, UK, you end up having the case name being a great emphasis. And so you'll have common law lawyers from the US and Canada and the United States. They'll be very quick to tell you the names of cases. Donahue versus Stevenson, Carlisle versus Carbolic Smokeball. I mean, common law lawyers are very good at throwing case names because that's the way they're trained and that's the way they understand how cases should be referenced. However, we look to other systems such as France, and you don't see a name being cited. Whether you have France, the decision, the date of the decision, and some other reference number. And so now you're starting to get confused. Okay, we have a database. How do we sort cases? We do it according to name? Do we do it according to cases? And this goes back to the structure of common law and civil law. In the United States, Canada, and the UK, most of Canada, there is a small part of Canada that's an exception. But in the United States and UK, it's a common law jurisdiction. So the way you reference cases is by their name. And there are reasons for that which we'll get into when we study the common law. But in France, the emphasis is on just the decision date and the number. And that's because France is a civil law jurisdiction. And in France, we don't want to emphasize the case name because we don't really care about the case name. And there are civil law reasons for that. Afghanistan, because of the historical trajectory that it's taken, largely has received the civil law elements from France as well as from Egypt. So we somewhat follow a civilian structure, even though in terms of substance, it's supplanted by Islamic law. But here in Afghanistan, what we have is really a civil structure. So even if you look, and I got this from the Supreme Court of Afghanistan, look at what it says, Kirar, Qada'i, and then the year, Dar, Qadaya, Qil. So there we go. What we have is, we have, Qatal actually, it's not Qatar. So what we have here is the case being referred to in very much the structure of France. There's no name here, we just have the date, we have a quick small definition about what the issue is, but there's no case name. So even if you look back to the way our own tradition here in Afghanistan has started to look at laws, we do follow a French structure. And there is a reason for that, because we are civil here in Afghanistan, just like France is civil, and we want to emphasize a way to reference it without going to the name of the case. So we don't want to get into UK and United States. This is important because you will actually come across, if some of you end up being analysts for the UN or whatever organization wants to make a database, you'll be faced with UK and United States lawyers, and they're going to argue with you and say that, no, let's start organizing the case according to name. And then you'll have to tell them, no, you don't understand the framework of the laws here in Afghanistan. Here in Afghanistan, the way it operates is that we look to France in terms of the civilian structure. we use France as our, France and other civil jurisdictions to how we understand the law, and that's why it's most appropriate that we decide the case, we reference the case according to the date as well as some other reference number. So it's another instance as to you have to really understand the legal foundation of the framework in which you're operating to be able to make right decisions when the time is important, and that so you don't start confusing principles that are at work here. Any questions? Okay, so then we'll go on to the last example. And this is the one that I sent to you, and it's somewhat interesting, and we come to it a couple of times in the class, and that is, how do we understand what set of law is most appropriate for a particular society? What arrangement is most optimal? So in Canada, polygamy is not allowed. It's just something that's not permitted by the law. Let's say in Afghanistan and many Muslim majority countries, Malaysia, it would be Indonesia, other countries, polygamy is allowed. And let's just take this fictitious country, I'll just call it Waristan, but there's no real, it's not Waziristan, just so you guys know. It's just Waristan, and maybe in this country, polygamy is encouraged. So then, how do we understand which law? Which law is the most optimal? You might come across this if Afghanistan ever wants to reform its family laws, which is very possible. I mean, this is always a discussion. Personal status laws are always being evolved and are always being revised. Should we look at if Afghanistan or any country that you're working in wants to revise their law? What should they look to? Should they go to Canada and choose their method? Afghanistan and choose their method? Waristan and choose their method? You won't really get an answer if you just look to the country and the law that's been enacted, because all it tells you is the end result of a real long and complicated process. The big issue is the why, like the discussions and the narrative that's behind these societies and the information that provides us the meaning as to why the particular law was passed the way it is. So in Canada, when we look at the why the law says polygamy is not allowed, well, we have to understand that there's an emphasis on formal equality, the way the constitution and the way the country operates. In Afghanistan, and in many Muslim majority countries, there is an emphasis that Islam permits polygamy, albeit with certain conditions. And I mean, those conditions are very important to discuss, and you discuss that in some detail in the family law course. Here I just want to kind of survey points. We don't want to get into a huge discussion on it, but we'll just say Islam permits polygamy and there are conditions with it. In this fictitious Waristan, what reasons might they have to actually encourage polygamy, hypothetically? And we can say hypothetically, this might be a post-war society. Women far exceed men and they have to deal with it pragmatically. So one way that the legislators decided to deal with this issue is that they encourage polygamy. They encourage a wife to have a male to be permitted having more than one wife, so that this post-war situation can be dealt with, and so women can have certain rights accorded by the law, accorded by marriage, but in a setting where women far exceed men because of the outcome of war, and a lot of men dying in that. This is just a fictitious example, and this is even a fictitious reason, because it's a fictitious example of a country, but what it's getting at is that there are different reasons as to why a particular law and position in the law has been passed. And for you guys, it's very important that you look at the why, and you understand, what is really underlying the law. What is the culture? What is what are the thought structures? What are the ideas based upon which people pass a particular law? Again, what we're getting away from is this, bare comparison of looking at a law, looking at a lot of different countries and comparing it, and you'll see maybe grammatical differences and some, substantive differences. But really, the meat and the gold of the issue is here when we talk about the why. Why do you see these differences in societies? So I hope that example is clear. This is just meant to get you your minds starting to jog your minds in terms of what are some of the issues that we'll be talking about here when we study comparative law. We don't want to, we're going to be looking into the richness of what underlies the law, and that's going to occupy us for the next 4 to 5 weeks. So it's a bit small here, but I'll tell you how the course is going to progress. We're going to begin off by looking at legal traditions. And so I'm going to go into this comparison between a legal tradition and a legal system. So in Afghanistan, like, we have a legal system in place. That system, has a civilian framework. It has a civil code. We have a constitution, civil code of procedure, criminal code of procedure. They have particular civil law structures, structural aspects to them. They also have Islamic law supplanted in them. And within this Afghan legal system, we have customary law that's very important. So let me just draw that. We have here in Afghanistan an Afghan legal system. Now, that legal system, and I know it's a bit hard to see here, but that legal system is informed by different legal traditions. So the Islamic legal tradition is something that began at the time of the Prophet, peace be upon him, and arguably earlier, and we'll get to that when we talk about Islamic law. But it began with the Prophet. It's been going now for over 1,400 years. It's collected a lot of information and a lot of understanding. So that understanding of Islamic law that's been developed over the last 1,400 years is something that has been impacting Afghanistan here in the way that our legal system operates. The Islamic tradition and all the information of Islamic law, as it's been developed over time, impacts the way we operate here in Afghanistan. The same thing when we talk about the civil law tradition. In the civil law, we're going to go all the way back to the 12 tablets, and this is going 5th century BC or a little earlier. The date slips my mind. But we're going to go back to the 12 tablets, we're going to go back to Justinian, and see how all that information has now become a part of the civil law tradition. And we take certain aspects of that. So what we have is, we have Islamic law tradition, we have the civil law tradition, all of the customary law, all of that is providing information as to the way Afghanistan's legal system operates. So these legal traditions provide information for the legal system. And we're going to go into that in some detail. But that's going to be the topic of our first little bit of the course. Then we're going to spend the vast majority of the course focusing on 4 legal traditions: civil law, common law, Islamic law, and customary law. So with civil law, Islamic law, and customary law, you can see why it has very pragmatic reasons as to why it's part of the legal system here in Afghanistan. But what's also important is understanding how common law plays a very important role as well. So we're going to look into civil law, common law, Islamic law, customary law. And what I mean that we're going to look into them, we're going to look into some of the prominent characteristics within these legal traditions. Like, what really makes common law common law? Like, why don't we call America civil law? What are these salient, sometimes the word bright line is used because, like, in the dark, a bright line is sometimes something that you see, kind of like a car, its headlights. So what are the bright line characteristics of these dominant legal traditions in the world? So we're going to spend probably 2/3 to 3/4 of the course focusing on these different legal traditions. And then we're going to get into ways in which we actually start comparing. Like, how do we move between legal traditions? How do we look at a law in the United States and then look to Afghanistan and decide, okay, now that we understand the structural framework and the bright lines of these legal traditions, what does that mean for the actual legal analysis and our comparison between the two? Like, what information can we get out of it? We usually end off a course, if we have time, looking at some interesting area of the law. One thing that students have really liked to do in the past has been kind of go into the area of law and development a bit, because in law and development, I mean, it's a very comparative field. However, there ends up being very little comparative law that's actually practiced. And so we get into the question, is it possible to do law and development work without comparative law or not? And the reason it's so important here is that law and development is a very big part of what happens in Afghanistan in the legal development. But that almost completely overshadows comparative law. You very seldom hear the word comparative law brought up. But it's an extraordinarily important part and parcel of the work of law and development. And so it's an important factor to keep in mind. And we try to do that by the end of the course. and students generally end up enjoying it quite a lot. So I'll skip this slide, we'll go through it when I get back to class. I'll just go into a little bit of the marking, and let me just make sure. It's a bit changed from what I have here, but let me just give you a quick rundown of what's going to be happening during the course. You're going to have a final exam, it's going to be 30%. You're going to have a midterm, it's going to be 25%. Then we get into some more interesting exercises. There's going to be a class assignment that's going to be 25%. And in that class assignment, you're working in groups of about 3 students, and you're going to prepare either an audio file or a video file. And in that audio or video file, I also give the students the option to write a paper, but no one has taken up the opportunity so far. You're going to work together to explain an aspect of comparative law. And I'll give you more details, but essentially you're conducting an interview. You and your colleagues are going to be doing an interview, and in the course of that interview, you're going to be discussing comparative law. So it's kind of a way of getting out of the routine exam and assignment writing, and actually getting you to discuss your opinions on comparative law. I usually have very early on in the semester a quick small assignment on, and it's just like a cover letter with a bit more of an exercise, just to kind of get you writing and thinking. And that's something that I'll be doing again this year. Now, I've changed it a little bit. I did presentations in the last year, but because of the way the summer is structured, it doesn't end up being the best way of doing so. So the last 10% is going to be a combination of class participation, like presence and absence, as well as a few quizzes. So there's going to be probably 4 to 5 quizzes throughout the semester, and I'll only take the best 3 of them. So you're going to have short, very short, 5-minute quizzes where I'm just going to ask you 3 multiple choice questions. Just circle the answer, and this is just to ensure that day to day you're actually doing the reading, because they're unannounced, these quizzes. There's going to be around 3 to 4 of them, and I'll drop there's going to be about 4 to 5 of them, and then 1 or 2 of them will be dropped, and that'll be taken into consideration when you have your class participation quiz mark, just as a means of making sure. It ends up being very beneficial for the student themselves, so it's a way to ensure that the student themselves has done the readings, and you'll end up enjoying the class a lot more because of it. So, attendance policy, you have to come to every single class, because once you start missing 1 or 2 classes, really it starts to get very difficult to catch up. I mean, imagine you were absent at the start of a $10 million case. Is that the way I talked about it? I mean, this time here studying at AUF, as well as getting information from courses, it is that $10 million case. It's that golden information that you're going to value for the rest of your life, and even in the way that you think and develop later on. And so make an issue to come to as many classes as you can. I usually allow 2 unexcused absences. Beyond 2, you start losing points, and after 4 absences, you end up failing the course. So I've never had to fail a student, but in many cases, students have gone from A to B and B to C. It's very sad that students, just because of their absences, end up losing an entire grade. But I mean, it's very important that you do end up participating in class by very first and foremost being here and being present. So very quickly about the way the format of the class is going to run, and that is the first quarter, sometimes even up to a half of class, I spend essentially just reviewing the previous class. We're just going to go over what we discussed, what were the salient topics of what were ideas that provoked people, and it's just a quick review to ensure that each time we're not forgetting what we carried over from the last time. Then I usually pose a couple of provoking questions, just to prompt individuals to see, did they do the readings, were they beneficial, what really stood out, and then we start going into the materials itself. I use a combination of the slides as well as the board. If I find it's getting too stultifying and too boring using the slides, I just move to the board itself. And so you'll see it's a very dynamic, a lot of high energy in the class, and you'll see that a lot of times I let you do the guiding, and I just draw arrows between the points that you bring out from the readings and you bring out from the concept that's being covered. And so I try to let you do a lot of the guiding, a lot of the discussing and identifying of points, and then I help guide that discussion so that we're heading in a certain direction. So this class is a class that's heavy on readings. I should make that known to you at the outset, that there's a lot of readings and they're tough readings. The reason is, you have to be, as you go on in your undergraduate progression, if you're in the social sciences, if you're in law, if you're in the humanities, you have to be getting used to complicated readings that take a lot of energy out of you. So I usually assign 10 to 20 pages per class, and so you have to be very careful to keep up with that in the summertime here, because we have classes 5 days a week. I think it's 6:30, and you're here in class now, so you've passed at least on that point. So about 10 to 20 pages a week. They're tough, so you might have to read them once or twice. And the class will help break down those readings. So we'll make sure that you understand the main point of those readings. And during the weekend, if you have to go over them and make sure that the breakdown that we did in class correlates with what you talked about, what is talked about in the readings, well, then that's something that correlates very well. But it's very important because if you're going to be a lawyer later on or going to work in the legal domain, you're going to have to be exposed to these very difficult readings and the way that you break them down and what's meant by them. What I like is that by the end of the course, these readings have helped students to be, one, confident, two, be able to dissect almost any level of reading, and three, it gives them the confidence to actually provide their own opinions. Because by the end of the course, they'll be realizing, wait, I don't agree with this author anymore. Because this author is saying, for example, comparative law is a method, but I believe that it's a field of its own, and you'll have your own reasons. And I'm very glad that students start reaching that level of analysis. One important point is this course generally puts you at a level where you would be adequately trained to start graduate school and have a graduate understanding. So it's not graduate level work. Sometimes it is, just by virtue of the readings that I haven't been able to find better ones. But by the time, and that's why you struggle sometimes through the course, but by the time you're done the course and have completed the readings, you're at a level where you can really understand the material and are ready for graduate school. So it prepares you very well in that regard. A very important point about academic integrity, and that is cheating is absolutely, there's zero tolerance. If I have to move a student during the exam, then right away they get a huge reduction of points. And you have to cite. You can't just plagiarize. Students can't just plagiarize works that they find from the internet or from another book. In the previous semester of this class, I'll be frank with you, I had one assignment and 10 out of the 15 students plagiarized. And it didn't go very well for all 10 of them, and student affairs is aware of that. So if you're going to cite a reading, you do have to, if you're going to use, materials from a reading, you do have to provide the citation, provide the quotations, if you're directly taking from it, but certainly don't ascribe it to your own work. I remember there was one semester where a student talked about structural hegemony and how that structural hegemony changes the imperative of legal states. Just language that I wouldn't use and people that I've studied for 20 years would maybe use. So, it's somewhat evident at a certain point that this work, might not be the most genuine. And so, even if you're going to cheat, make it a good effort in doing so. But better than that, don't cheat at all. Just make sure you uphold academic integrity. And don't worry about this because we don't do this exercise. Last of all is make sure to come by my office at any time if you have questions during the semester. It's an evening course, so I'll probably be here mostly in the evenings in the 1 or 2 hours leading up to class. And my office is on the 3rd floor of the Byatt building. So if you turn to the left when you reach the 3rd floor, you'll head towards the president and the administration. If you turn to the right and go to the end of the hall, you'll hit my room. And if nothing else, it has a good view of campus, so you can see which friends are walking around and what the day is like on campus. So with that, I won't keep you for too much longer. I'll tell you that we won't have class the next 2 days, but and I'll be emailing you, but on Thursday, we are going to come back in class and you're going to see a very interesting video. And this video is of a real case that actually took place in the United States. And that case is assigned for you as a reading for next class. And the video is just extraordinarily interesting. You're going to see how this case of a baseball game ended up becoming this long, drawn-out legal battle in the courtroom. And it tells you a lot about the common law as well as the way litigations occur in the United States. And of course, that's going to inform the way we understand comparative law overall. And I think you're going to enjoy that very much, that video. And it's very important that you do attend because just like today's class, and the way I talked about Afghanistan's banking law and Canada's banking law, it's something I refer to throughout the course, similar to that video that we're going to talk about next on this coming Thursday. And just to leave you with some food for thought, I actually ask you to think about this before you, as you start the semester. And it's this question of, thank goodness, we're done the PowerPoint. It's this question on whether, is comparative law a field of its own, or is it a method? And there are interesting reasons why you would say both. One, you would say it's really a method, because we don't just talk about comparative law, but we talk about a course that we have here at AUAF, comparative constitutional law. Constitutional law is the content, and what we do is we just compare using a particular method. Similar to property law. There's property law in Canada, United States, India, and Afghanistan, and comparative law is just a way to compare between the two. So this would suggest that comparative law is nothing more than just a method of comparing. But there are many others that say that no. It is an actual field of its own, because what we want to study when we're doing comparisons is this nature of interaction. So law doesn't necessarily always mean enacted law that's written and something that people have to follow. It can mean that you look at the nature of interactions, and the way we look at these interactions, the information that surrounds what type of interactions we should be looking for is very important and constitutes a field of its own, and a field worthy of independent study. So I ask you to ponder on that question. Is comparative law a field of study or a method? And critically, what are the reasons for it? So thank you very much for being such a great class today. I mean, it's probably the quietest class that I've ever had here at AUAF. There were no questions asked. So thank you very much. Inshallah, I'll see you in the coming days, and I hope you all the best as you start your semester. And while I won't be here this week, make sure to email me if you have any other questions. Provide me, and next week onwards, stop by my office. And also thank you everyone here in the classroom. I mean, you can see how popular this classroom was today. See? So thank you very much for the audience as well. All right, so with that, I'll see you in the coming days. Assalamu alaikum.